Hi, everyone. I'm Ben Werner. I lead marketing here at Privado AI, and we're excited to have you for another webinar. We've got two absolute experts in children's privacy, and there's a lot that's been happening on this topic just this week, actually. So, yeah, Amelia Vance and Daniel Hales have updated their presentation just yesterday based on some of the developments. And yeah, I think Amelia is very excited to speak about the all the things going on today. So, oh, there's an echo. Um, yeah, I'm not sure what to do about the echo. Maybe that's me, but I won't be talking very much. So, just as a introductory housekeeping, please do put your questions in the Q&A throughout the presentation. They will try to answer them as we go. If not, get to them at the end. This webinar will be sent out the recording, the slides afterwards, so look out for that. Otherwise, yeah, I will kick it off to Amelia Vance and Daniel Hales to introduce themselves.
Perfect. Daniel, you want to kick things off?
Sure. I'm Daniel Hales. I'm a policy counsel at the Future of Privacy Forum. For those that don't know, the Future of Privacy Forum, or FPF, is a global nonprofit organization that advances principled and pragmatic data protection, AI, and digital governance practices. I work specifically on the U.S. legislation team, leading FPF's legislative portfolio for youth online privacy and safety is inclusive of the legislation, regulatory, and enforcement activity, and all of the constitutional challenges going on. So clearly a very big time. Amelia.
All right. Hello, all. Amelia Vance. As many of you likely know, I've been working in child and student privacy for over a dozen years now. And it is certainly the busiest time that we have seen in that time period. I run a nonprofit, the Public Interest Privacy Center, which also focuses specifically on these issues and providing resources and information like we are today. So let's get started. So I always think it's really important to provide information around the why. So what we are seeing in legislation and what you are going to be required, if you haven't been already, to do is really based on what has happened. What are the headlines? What are the concerns that have popped up? And so, if nothing else, you remember from this, uh, know that looking at the headlines and keeping aware of the common concerns is going to help you stay ahead of many of them. And so, what have the headlines been? We've seen obviously more and more concern over children's data and tech companies. We've seen the cutting edge of worries about AI companions and kids. Um, and in many ways, everything privacy, at this point, much to my joy, is centered around kids. The stuff that is passing, the laws that aren't labeled as kids include kid stuff. And so just looking again at these concerns, if you remember nothing else from this, will help you follow, okay, these are the protections that have been put in place or are going to be put in place. So, COPPA, this almost feels antiquated at this point because what we got the final Federal Register published version of the new COPPA rule in, I think, June last year. So it has been in effect. It has not yet been enforced. So you have final rule released, updated rule going into effect in June, and regulated entities must comply coming up very soon. So some key changes, and I'm not going to go too deeply into this because it's just one of the very many things that are happening. So it requires opt-in consent for disclosures to third parties. There's no consent bundling with parents anymore. It's very important that separate parental consent be given under the new rule. There's limits on data retention. This was the only non-waivable part of COPPA before this. With most other provisions, parental consent could waive, uh, the ability to use data or not for targeted advertising or profiling or things like that. But the FTC got a little more specific and said there has to be a policy, et cetera. And then there were, thankfully, some definition updates, which were definitely long overdue, including actually spelling out that mixed audience websites or online services are, in fact, a separate definition. So they're no longer a subset of the things directed to children. So, going through in a little more detail, all these slides will be shared. So, unless a disclosure of information is integral to the website or online service, the operator has to give the parent the option to consent basically each and every time. Separate verifiable parental consent to each disclosure. It's worth noting that non-integral disclosures probably also includes using data for AI training. So we will see how this ends up applying and how the FTC chooses to apply it. But this is perhaps the biggest thing that everyone has to be ready to put into effect immediately. Again, having the separate consent requirement in ways that are flexible, but again, want to make sure that you really are giving an opportunity to consent to the specific uses that are integral and those that are not. Disclosures. So when the operator discloses personal information to a third party, identities or specific categories of such third parties, and the purposes for the disclosure, if the parent should provide consent, and that the parent can consent without consenting to the disclosure to third parties, except when it's integral to the website or online service. Advertising is not integral to the website or online service and would require consent. As I mentioned, we now split up the directed to children, mixed audience, and actual knowledge standards, so it's a little clearer. So we've seen this in the COPPA Q&A for quite a while. So mixed audience, specifically defined as a website or online service that is directed to children under criteria, but that does not target children as its primary audience and does not collect personal information from any visitor other than for the limited purposes set forth prior to collecting age information. And any collection of age information or other means of determining whether a visitor is a child must be done in a neutral manner that does not default to a set age or encourage visitors to falsify age information. None of this is new. People still get in trouble for it. But this really, in many ways, is just codifying what we've seen prior to now. We have a good question that I'm going to go ahead and respond to. Does integral equal functional? If I'm interpreting functional right, it's very much so if it is necessary for the service. We'll see exactly how the FTC decides to define that. Obviously, we've seen similar tests under a lot of the consumer privacy laws, under the kids' privacy laws. The FTC, well, children's privacy is top priority. They're also more likely to be flexible on what is integral right now, but we'll see. Daniel, do you have anything to add on that point?
No, I think that where I'm falling on this aligns with what you said that there may be some willingness to be a little bit more flexible on what is integral right now as this enforcement starts to go into effect. It will probably be figured out over time, but for now, I think that flexibility is where I'd lean.
Perfect. So I'm going to skip over the next couple slides pretty quickly because it's more quotes about what this is. Again, we'll share the slides after, but other things that are in the rule. Covered entities need to maintain a written data retention policy, again, more specific than we've been in the past. It has to detail the specific business need for holding on to kids' personal data and the timeline for deleting the data. I'll note that the chair of the FTC, Commissioner Ferguson, actually isn't quite the right terminology, but dissented on this aspect of the rule, and was really concerned that it was too prescriptive. This matters because he's noted, I think first last November, that the FTC is interested in regulating an update to the COPPA update. And so if anything got rolled back, it would likely be this. But again, the original statute, the rule, have requirements around data retention. So just be aware that this one might end up shifting. And in the short term, you have to have a written data retention policy, and it can't say, we'll keep it until we don't need it anymore. So given the expansion of AI and machine learning tools that feed on data to develop and refine models and algorithms, the FTC has noted, in their enforcement experience, firms have cited machine learning as justification for indefinite retention. The commission has made clear in those settlement actions that these AI training claims do not override legal bans on indefinite retention of data. So you have these little bits and pieces slipped in throughout both the final rule that was released in January and elsewhere, where it starts to tell us how to apply COPPA to AI. The other really big thing I wanted to emphasize is biometrics. So the FTC decided not to add any additional exceptions to the COPPA rule related to biometric data. So there is an allowance for the collection of audio files containing a child's voice. This is very limited, but that was as far as the commission was willing to go at that point. So commission said the impact on such uses and the burden placed on operators to obtain consent are outweighed by the benefit of providing greater protection for this sensitive data and enhancing control for parents. And storage of sensitive biometric identifiers for even limited periods of time increases the risk that the data will be compromised in a data security incident. So at least within these sections, which the current commissioner did not dissent to, there really was a limited level of tolerance about collection and retention of biometric information. And I was most struck in the initial, what was it? The notice of proposed rulemaking, but the first pass at the new rule, where they actually said that there was no way for example, voice data to be de-identified. So a lot of the things that I think people have taken for granted about, what can and cannot be done business-wise has shifted a little bit in the new rule in ways that you may not necessarily realize by just scanning the rule text itself. So, very importantly, we also now have new FTC guidance in the form of a policy statement. So, very recently, think just a couple weeks ago, though it feels like it's been years in the past couple weeks, the commission has said that they will not bring an enforcement action against an operator that collects, uses, or discloses personal information for the purpose of determining a user's age without first obtaining parental consent. So, in order to see whether someone is a child, the FTC has said as long as you delete the information, don't retain it, go back to all of the rules and regulations you have to do under COPPA. When you are first collecting information to tell you whether or not someone is under 13, the FTC isn't going to go after you for using facial recognition or estimation or all of the other forms of age verification. So, seeing more and more state laws, we'll talk about in a minute, that pushes that, but very important to know that this policy statement came out and it's likely going to be what we would see in a new COPPA rule if the chairman decides to move forward with another rulemaking. So I won't go through this in detail, but according to the new policy statement, operators can only use or disclose information for age verification to verify users' ages, take reasonable steps to ensure third parties that receive information collected for age verification maintain confidentiality, security, and integrity, will not use or disclose that information for another purpose. And this is going to be probably the most important under both this policy statement and a number of the state laws, will promptly delete this information after verifying a user's age. Let's move to the next exciting topic. So I always love sharing this map, this quilt of messiness happening. So as of like a week ago, 10 days ago, this is updated. Here are all of the specific laws related to protecting children online. And Daniel in a minute will go into the various types, but this really gives you a sense of how complicated it is right now to try to figure out compliance, because not only do you have all of these disparate laws, you also have laws layered on top of each other. And so figuring out all of your obligations is vital, but extremely difficult right now. Free Speech Coalition, I always love to look at their state age verification loss map because it tends to be the most up to date. As you can see, all of these laws are in effect unless they're enjoined, which we'll get to. But these are all of the states that have put forward some requirement for age estimation, age verification, etc. Daniel.
Yes. So I'm gonna try to, as concisely as I can, go over the main legislative frameworks, but obviously, as these maps have demonstrated, it is a very complicated patchwork right now. And so, in order to best organize what's going on, I've identified four main legislative frameworks that are going around right now. And I identified these four because they're the ones that have resulted in some sort of enacted law to an extent, but there's certainly some legislative experimentation going on as well. The first one to note is age appropriate design codes, or AADCs. These are evolving and potentially diverging frameworks right now, but I'll start with the first one, which is California, which was the first to enact one in the States, but is not the first one to just come up with this legislative framework as a whole. California took the idea of an age-appropriate design code from the UK and retrofitted it for California law. First enacted in, I believe it was 2022, and then it was very quickly caught up in litigation. Basically, it would have required legal entities that met certain processing thresholds and that were reasonably likely to be accessed by children, to design within the best interests of children. It included DPIA requirements, some data protection obligations, such as uh, limits on geolocation processing and dark patterns prohibitions. And it had also included an age estimation requirement. I sometimes refer to it as a soft requirement, though, because this specific requirement was that covered entities either had to provide the protections that were required under the Act to all consumers that visited the online service, or they had to conduct age estimation to identify who is a minor and then apply the minor specific protections to the minor identified users. But like I said, that was very quickly caught up in litigation for a variety of reasons. Plaintiffs that challenged the law did so on constitutional grounds, arguing First Amendment concerns because of the potential regulation of content through DPIA provisions, challenged the age estimation requirement, and a few other provisions. The litigation is still very much ongoing, and we will actually have a slide a little bit later where we'll touch on the current status of that, because there was a recent Ninth Circuit decision within that litigation within the last month. There's also Maryland that followed California. Maryland then took inspo from California, but changed things after seeing what was coming out of the litigation. For starters, they provided definitions of some critical terms that California had omitted, such as a definition for what is best interest of the child in this context, and definitions of what is material detriment and some other key terms there. They also omitted any references to age assurance, which was another main criticism of the California law. But it still had this idea of best interest of the child, and still took this more traditional design code approach. The following year, so last year, we then saw Vermont and Nebraska come out with age-appropriate design codes, and this is where we start to see some evolution and divergence in the frameworks. We do not see in Vermont or Nebraska best interest of the child standard. Vermont actually switched to a different kind of fiduciary duty. They adopted a minimum duty of care standard. And Vermont did not go with any sort of fiduciary duty. It only includes data protection requirements for minors. And then finally, this year, we get to South Carolina, which once again kind of took the framework and did something different. South Carolina includes a duty of care, and it has that broad scoping of online services reasonably likely to be accessed by children. However, it has, first of all, I think very notably, it has protections envisioned for all users, not just minors. So it's kind of broadening out this idea of, age-appropriate design that's not just minor exclusive. And then they have heightened protections for minors and require that protections that they envision in the act are provided to minors by default. It also takes inspiration from Nebraska's approach of limiting certain personalized offerings and certain features, design features such as like limiting, being able to limit infinite scroll, autoplay, etc. But South Carolina is also notable because instead of DPIAs, they approach uh, sort of annual review processes through audit requirements. And then it has a very unique liability provision, being that under South Carolina, employees can be held personally liable for willful and wanton violations of the act. And it allows for treble financial damages. So it kind of upped the stakes. And South Carolina very critically went into effect as soon as it was signed by the governor back in February. So it is currently in effect, and it changes the game, I'd say, for age-appropriate design codes here. Quick note, all the asterisks next to the states are states that have either been challenged in court, or the laws that have been challenged in court, or that have been enjoined or partially enjoined, to give a little bit of that landscape there. Um, Next, we'll move on to age signals frameworks. So there's age signals frameworks really emerged last year. It's a newer legislative framework that we're looking at, and there's two that have been enacted. There have been other visions for what age signals framework can look like, but some of those other models have not been enacted yet. So I'm focusing mostly on what we've seen come out with App Store Accountability Acts, and then the Digital Age Assurance Act, which we saw come out of California. App Store Accountability Acts require age verification and parental consent at the App Store level and requires that that information is transmitted to developers via API signals within the App Store ecosystem. And it requires that these signals are transmitted whenever a minor is trying to download an app, make an in-app purchase, or in the event of significant or material changes, however the law phrases that there, there has to be a renewed consent for a minor's continued use of the app. There have been a few states that have enacted the App Store Accountability Act model so far: Utah, Texas, Louisiana, and Alabama. Texas was supposed to go into effect January 1st, but it was enjoined last year on December 23rd, just before it went into effect on constitutional grounds, and that litigation is ongoing. I believe it is on appeal in the Fifth Circuit currently. Utah has been challenged, but there has not been a ruling on the preliminary injunction, which was just filed at the start of this month. Utah's preliminary injunction may be complicated by the fact that Utah has currently just recently amended its App Store Accountability Act to address some of the things that it was challenged on. So we'll see what the course of that litigation is going to be moving forward. Still think it's going to be caught up in litigation, but that timeline may be shifting a little bit now. Louisiana has not been challenged yet, but I do believe that there has been reporting on an expected challenge to that law. And then Alabama recently enacted their App Store Accountability Act just this year, I believe it was last month. And so that is a another version of this model that again tries to take into account some of the constitutional concerns, but at the same time, I think that there's also been reporting that that is expected to be challenged. And then California enacted the Digital Age Assurance Act, and it involves age signals, but it is different than the App Store Accountability Act models because under the California model, operators are required to implement age declaration at the point of like mobile operating system setup. And then the age range of a user is then supposed to be transmitted to developers through the App Store ecosystem on, I'm assuming the operating system, but the App Store specific responsibilities are not exactly defined in the bill, but that seems to be my assumption when I read it. So this does not require age verification. It does not require parental consent. The goals that were stated by the legislators when they were enacting or pushing this through the process and ultimately enacting this law is to start to facilitate age sharing information to trigger obligations under other laws such as COPPA or the CCPA, and start bringing more awareness to who is a minor online to try to trigger some of those additional protections that are being enacted under other laws. So it's a lighter touch version of what we are seeing in terms of age verification and age signals frameworks. Moving quickly through social media and privacy laws now, there's also social media regulation or design feature regulation laws. I kind of combine these two together because oftentimes the design features that are targeted are ones that are primarily found on social media, or the design feature regulation is basically just targeting social media platforms' use of those design features. So, starting broadly with just social media regulation, there is a very strong trend among the states to pursue various regulations of social media laws, but the most common elements of these laws is some sort of age verification requirement with parental consent tied to that for a minor's use of a social media platform. There may also be requirements for implementing parental controls or allowing parents certain access to a minor's or their child's account settings or platform use information, such as how much time they're spending on the platform, the ability to set time limits, etc. And it could also include some data protection or default safeguard requirements. That is the most common version of this framework that I see. However, there are stricter versions of social media regulations, such as attempts to ban social media for minors, primarily under the age of 16. I think Hawaii is on the cusp of passing such a service ban at this point. But that's primarily what we're seeing in so far is social media regulation. There have been quite a few bills, or I guess at this point, laws that have been enacted in the past, I'd say like 3 years is where we've really seen a lot of this activity. But so many of them have been enjoined that, and we will get to that in a few slides and showing a fun little chart with a lot of the enjoined laws and lawsuits going on. But I did not list them all here for the sake of space. And then aside from social media regulation, sometimes there's just design feature specific regulation. So that we see that in New York and California. In New York, there's the Safe for Kids Act. And in California, there is a law that is very similarly named, and both of them target so-called addictive feeds. And it basically requires age verification and parental consent in order for social media platforms to provide minors under the age of 18 with algorithmically curated feeds. And then it would also include some other obligations, such as restricting nighttime notifications and limiting, I believe it's infinite scroll capabilities. New York is in a very robust rulemaking process for the Safer Kids Act right now, and it is not going into effect until that rulemaking process is done. And it has not yet been challenged. But California, on the other hand, had been challenged after enactment. And there's a recent Ninth Circuit case that lifted most of the preliminary injunction in that case, and so that is now currently going into effect. But I will flag that the age verification requirements are not set to go into effect until I believe January 1st of next year, and the specifics of the age verification requirement are going to be determined through rulemaking that is going to be kicking off pretty soon in the state. Um, Also flagging, I did a quick flag of Mississippi here, which is, I'd say, a unique law because it's a social media regulation that is currently in effect. Most of the social media targeted laws, I think, Amelia, correct me if I'm wrong, all of the other ones that I've seen have been enjoined to some extent, either partially enjoined or fully enjoined. Mississippi is not enjoined at this point. It is still actively in litigation, so it could very much be overturned or not in effect soon, but it is currently in effect now. And then finally, privacy laws. We have to always remember privacy laws. There are right now, after Oklahoma, which was recently enacted, now 20 comprehensive privacy laws. And then there are some more bespoke, minor focused privacy laws in the states as well, such as the New York Child Data Protection Act and Arkansas, which enacted a version of COPPA 2.0 in the state last year. And very important to pay attention to the various comprehensive privacy laws, to keep an eye on the various opt-in or opt-out requirements for teen data processing, or in some states where there is a restriction on certain data processing activities when it comes to teens. I believe Maryland, for example, bans targeted advertising to teens in MODPA. So very important to figure out the patchwork of different requirements there. And then New York Child Data Protection Act basically provides like a minor specific version of these data protections that we commonly see in comprehensive privacy laws. Requires informed consent for data collection, use, processing. For children under the age of 13, compliance with COPPA means compliance with the state law for children 13 to, I believe it's 16 or 17. It requires informed consent there. And this New York Child Data Protection Act is currently in effect, but there is some flexible enforcement going on right now from the OAG, who released implementation guidance but hasn't yet completed full rulemaking for the act. And that process is ongoing. But certain provisions under the New York Child Data Protection Act, such as compliance with browser signal obligations, um, it's not something that they're currently enforcing very heavily until they have the rulemaking for those requirements completed. But I know that we have a couple of slides displaying some of the requirements to pay attention to that would relate to the comprehensive privacy laws. So I'll pass it back to Amelia to walk through those awesome graphics to provide more color to what's going on.
Literal color.
Yeah.
So yes, most of you already know this, including that Oklahoma is now on the map. But what people don't necessarily think as much about is that almost all of these laws protect kids in a different way than adults. So this is a map of the consumer privacy laws that say that data from a known child is sensitive. And this actually goes to a question that was asked. Yes, no one should assume that they only have to do under age 13 anymore. I would say at this point, with the laws that are in place, you should generally assume that you will have to provide protections for anyone under the age of 16, and then look very carefully at these states where you may have to have data from children under 18 or under 17, where it really is, you have the heightened protections for any data from a known child, including shoe size, etc. And so, again, you can layer this on to the other requirements. And then you also, of course, have things like limits on targeted advertising and sale. This is certainly one of the things that it's most restricted. And so this again helps you see sort of the different ages here. So consent required by minors under 17 in our purple states, consent required by minors under 18 in our light blue states. You have not very many that do under 13 anymore. This is really a massive shift. And it is, I would say, going to move forward no matter what. So, teen protections on your to-do list. So, new and exciting. We also have AI companion and chatbot bills that are, in one case, now law, and I think the other one is still awaiting the governor's signature, though, as noted, the Washington state one was signed yesterday. So, breaking news. So, these laws were really brought up due to the reporting and other information related to um, kids having long-term conversations with chatbots and it leading to self-harm or mental breaks or other really horrific things. And so these bills moved relatively quickly and are already passed. So, really quickly, Oregon requires disclosure to consumers when they're interacting with an AI chatbot, prohibits emotional manipulation, sexually explicit content, addictive rewards. It does, however, exclude video games, voice assistants, and education software. Washington requires companion chatbot users to receive notification they're interacting with AI, and operators must maintain protocols for detecting and addressing suicide ideation and harm. Use reasonable measures to prohibit the chatbot from engaging in manipulative engagement techniques to keep minors engaged. This also has an exception for video games, voice assistants, and a much more narrowly tailored subset of educational tools than Oregon's, which takes us beautifully into state legislation. So let me actually go ahead, since we were just talking about chatbots, and let all of you just stare at this map for a moment. It is March 26th, and I think there's actually more bills than this at this point. But within, I think, the first like 5 or 6 weeks, of the 2026 legislative sessions, we saw 76 proposals specifically on AI chatbot and companion regulation in 27 states. 78 as of a short time ago. I think, Daniel, you have more information there. So let's go ahead and dive into what are the common provisions.
Yeah, so great colleague on my team that is putting in all the hard work of tracking all the AI legislation, inclusive of the many, many chatbot bills. And I think that there's new bills introduced every week at this point. He's put together a really great resource that breaks down the common components and obligations of these chatbot bills that are being introduced. And there's six of them, but I had to break it up into two slides, so make sure that we could all see what was going on. The first is, and so many of these common provisions do implicate minors either directly or have specific heightened versions of the requirements for minors. So, like transparency, like provisions that would inform users that they're interacting with a system and an AI system, that it's not a human, and figuring out whether that transparency or that disclosure is needed to provide to all users or to minors only, or if it has to be provided to minors more frequently than all users. There's oftentimes age assurance and minors access controls requirements and some sort of parental consent involvement there. There's so many of them that involve content safety and harm prevention. And again, this can be, these kinds of provisions can be heightened in terms of the obligations companies owe regarding minors. Next slide, please. Thank you. The professional licensure and regulated services isn't as minor specific, but the data protection requirements certainly can be, because there is a growing subset of chatbot bills that would restrict use of minors' data for AI training. And then finally, there are different liability and enforcement mechanisms that we are seeing coming out of this. Lots of action, lots of different takes on these common provisions, but this is generally what we're seeing coming out of the influx of chatbot bills this session.
I would note that a really interesting aspect here that Daniel touched on is that, in these bills, go back to our map here, sometimes the requirements involve monitoring users at a pretty detailed level. There has been a lot of, duties to get back to parents about self-harm behavior. Lawsuit recently filed about a school shooting in Canada that the shooter had been essentially going back and forth with OpenAI's chatbot, I think 8 months before the shooting. They got in trouble. They were able to sign up for a new account and continue planning out an act of violence. And unsurprisingly, ChatGPT has been sued. So we are seeing, at the same time as we're seeing restrictions on how minors' data can be used and what the requirements are, we're also seeing these monitoring requirements that say that companies have to keep an eye on what their users are doing. So we'll see how this plays out one way or another. It's still very much so a live issue. Um, so other state legislation things, there's been a lot that was talked about, and Daniel, I'll maybe toss it to you in a sec, but just to note, age verification, it's still everywhere. So you can see here the states where a law was passed before 2026. That's our lighter-ish gray. It's hard to tell. You have laws that were passed before 2026 and have a pending bill. That's our almost black colored states. And all of the red states have a pending bill this session. So when you look at this, there are, what, I think 4 or 5, about 10 states that don't have a proposal or haven't passed a law already. This is an overwhelming trend, and it's very important for folks to pay attention to it. We'll go into some of the litigation stuff in a minute, but this is a huge potential liability if you don't have a level of age verification. Um, Daniel, anything to add on the state legislation?
Oh man, I think that we covered it pretty comprehensively. The four primary legislative frameworks that I mentioned before from the enacted legislation that we've been seeing really is translating to the ongoing legislative trends that we are seeing from this session. There have been more age-appropriate design code or inspired kinds of bills introduced this session than I've seen in any previous year. I think that Michigan has one moving right now that we may see coming out the other end soon. So paying very close attention to that. Age signals laws, App Store accountability acts are very huge right now. So definitely monitor and pay attention to those because of how broadly applicable those laws are. It just applies to, app stores and then all developers. So anyone with an app on an app store will have to pay attention to the requirements there. And then definitely the shifting nature of privacy laws is the last thing. And again, one thing that I'd reiterate, and just because it came up in a question, it's something I think about all the time. So many of these laws are raising the age threshold. We aren't just talking about kids anymore. We really are talking about minors, either up to 16 or more and more these days up to 18 now. So figuring out how to retrofit your compliance programs up to teens is becoming a growing imperative in terms of the laws that are being enacted and regulatory um, uh, priorities at this point, which we'll get to.
Perfect. All right. We're going to go ahead and really quickly, since we're not quite out of time, but we're getting there, really quickly fly through the rest of this because it's really important to have a level of awareness about all of the different things that are happening. Um, so we sort of alluded to there are lots of legal challenges to the state laws, particularly regarding age verification, for access to social media or other sort of broad sites. Can sort of see the overall numbers here. And again, we'll share slides, the status of a bunch of these lawsuits. And there was sort of a wrench thrown in what is legal, what is constitutional with last summer's Free Speech Coalition v. Paxton, which essentially said states can absolutely require proof of age for minors to access content that is obscene. Age verification requirements to access content that is obscene to minors triggers intermediate scrutiny versus strict scrutiny, and the burden on adults to prove that they're adults, including verification methods that involve having to provide a government ID, should be viewed as incidental. What we don't know and what is being fought out and will end up at the Supreme Court is whether the court will apply intermediate scrutiny to laws regulating access to non-obscene content, such as the laws mandating age verification to access social media, and how courts will balance child protection interests against privacy concerns. You have to be identifiable on the internet in non-obscenity contexts. And always worth mentioning that the Mississippi law that Daniel mentioned that went into effect was the Supreme Court said, yeah, that's fine. That choice hasn't made its case that this will be harmful to their members, but you had a concurrence to that from Justice Kavanaugh noting that in his view, Net Choice has demonstrated that it is likely to succeed on the merits, namely that enforcement of the Mississippi law, to be clear, it's being enforced, it's in place, would likely violate its members' First Amendment rights under this court's precedents. The phrasing there is important because before last summer, the court's precedents were clear that age verification was unconstitutional. So these laws are often considered unconstitutional because of a couple things. It regulates delivery of constitutionally protected content, because that content is considered harmful to children. Courts find that it is often under-inclusive. For example, Google search results won't be impacted regardless of what they show young people, but Instagram would be on the hook for a broad amount of content. It's been found that they are overbroad, applies to broad swaths of the internet, not specifically companies or platforms that have content that's specifically harmful. The laws are considered vague, worrying that this will lead to over censorship in order to try not to violate the law. Um, Also, unconstitutional because coercing largest social media platforms into blocking or filtering a variety of legal content causes some issues. Unconstitutional because it makes kids less safe or more likely to be harmed due to its likely impact in restricting speech and access to information for politically targeted or marginalized communities. Subjects a large portion of users to privacy invasive age verification, forces private businesses to act as censors for the state, and stifles the editorial independence of web publishers. Not to mention, it could very likely be weaponized to promote or eliminate specific viewpoints. To be clear, I'm not making these arguments. These are the common arguments that show up. And to put that more simply, people say that it could restrict the constitutional rights of adults, minors, and companies. And so this really shows why there are so many court challenges and the difficulties there. So the first huge court challenge we saw was the challenge to the age-appropriate design code in California. And fascinatingly for all of us, we got another Ninth Circuit opinion very recently, which said that there are provisions of the law that can go into effect. So it is not unconstitutional for the very broad, likely to be accessed by children, companies to be regulated. Age estimation, considered constitutional. And they mentioned as well the high standards, high privacy standards by default being something that was likely okay. And then there were a couple other provisions that were considered unconstitutionally vague, which is what we had seen in some of the previous California rulings. But each state that passed a successive AADC tried to clean up their language such that it would pass court muster based really on the things that the district court and the Ninth Circuit found in this case were unconstitutional. Federal legislation, very quick. COPPA 2.0, COSMA, and COSA. You have all of the bills, possible extension of COPPA 2.0. You have a Kids Online Safety Act, which expands a duty of care. Kids Off Social Media Act requires social media platforms to ban all minors under 13. COPPA 2.0 and COSMA, interestingly, are the most likely bills to move because there isn't great opposition, or at least there wasn't until preemption was put into a number of the proposed online child privacy and safety bills by the House in December. However, COPPA 2.0 might actually pass now. It passed unanimously through the Senate, and an amendment by one of the co-sponsors at a markup a couple weeks ago took out the preemption language. And so we're left here with very few provisions that are substantively different. Really, one that is going to be a fight around the knowledge standard. But otherwise, this shockingly could become law. I mean, I wouldn't bet on Congress getting much done, but you'll note that regardless, there is bipartisan consensus that all of those under age 17 will receive new protections. And then you have a bunch of others. There's a huge legislative package that you'll start to hear about, bringing together sort of a version of COSA with a bunch of other bills. COSA itself, Sammy's Law, restricting sort of ways to get drugs on the internet, an App Store Accountability Act. So much happening here. Again, with COSA, protections up to age 17, and it keeps going. I think yes, almost all of these happened in the last 2 weeks, where Senator Markey literally just introduced new legislation to protect children from privacy and safety risks. I think he announced it today. Ted Cruz said, despite, COPPA 2.0 and other things passing, they're going to be pushing more kids' safety proposals in the next 6 weeks. There's a lot happening, not to mention the general laws like Senator Blackburn's new national policy framework for AI, which includes a duty of care in the same way that existed in the Kids Online Safety Act. On the White House side, you may be asking, well, aren't all of these laws going to go away? No, absolutely not. So we know with the executive order that there was sort of a level of saying that child safety laws would not be challenged, that the White House and DOJ would not go after states that were restricting innovation by passing a kid's privacy or safety law. But we also saw in the past month exactly that happening with a bill out of Utah that was pulled back after communications with the White House. So whether or not some of the laws, particularly in red states, move forward that touch on AI is an open question. And it still is under the National AI framework that was just put out. You do have a number of provisions that say Congress, when you pass something, allow these things to still exist. But it's ambiguous. And whether or not these laws can move forward, whether they'll be challenged by the White House, is up in the air. But I think, do you want to really quickly, go through some of the enforcement trends?
Absolutely. How can we talk about all these laws and obligations without talking about enforcement trends? So I will go through this quickly and then wrap it up in a few key takeaways for people to walk away with about what's going on in enforcement. So starting with recent federal enforcement actions, these are just some of the enforcements from last year. There were some others that involved minors and teens under Section 5 of the FTC Act, but I've omitted those for now and just focused on COPPA because I think that this is what is going to be the biggest enforcement trend of this next year. Not just from my personal belief, but just statements that Commissioner Ferguson has made. In many, many speaking engagements over the past year that this is going to be a year of COPPA enforcement. So highlighting the COPPA enforcements from the past year, there were three major settlements that came out. And the commission broadly alleged in each of these that the companies violated COPPA by knowingly collecting data from children under 13, whether they knew that these users were children through self-declarations or because the services had child-directed targeting, which seems to evidence that the company knew that they'd have children on the platform, and that the companies then failed to implement measures that allow for required parental notice and consent. So it's kind of just getting back to the bread and butter of what COPPA is. But very importantly, needing to pay attention to that knowledge component and paying attention to, yes, the user declarations, but also especially the kinds of content and child directing that may be on the platform. And in the state, there is a couple of different actions here. So there's some privacy enforcements, and then there's some consumer protection enforcements. In the privacy enforcements, there were two in California where state regulators alleged that the companies, Sling TV and Jam City, did not obtain the required opt-in consent from minors under 16 or from parents of children under 13 under the CCPA. Again, going to continue to hammer this back home. Growing imperative to pay attention to providing the required opt-outs or protections for teens under these laws. In Michigan, the Attorney General brought COPPA enforcement action, which state attorney generals can also enforce COPPA, which is an important reminder. And the action was against Roku, alleging that it collected and used children's data without parental consent, despite knowing children used the service, as evidenced by that child-directed content, such as kids and family sections, popular free kids movies and TV shows recommendations, and advertising aimed at children. So all of these different elements that may appear on online services can be indicia of knowledge that children use the platform. And then finally, in Florida, the Attorney General brought an action also against Roku for similar reasons, knowing that the company alleging that the company processed the sensitive data of known children under 13 without performing age verification and obtaining affirmative authorization from parents for the consent and processing sensitive data, which violated the Florida's Digital Bill of Rights Act, a version of a privacy law, but not one that I consider comprehensive. Um, and then on the consumer protection enforcement side, there have been a lot of consumer protection lawsuits filed by state AGs in recent years, and there were many filed last year. And these consumer protection lawsuits are under the Unfair and Deceptive Trade Practices Act. And it's basically an attempt by AGs with a novel legal strategy to go after alleged online safety deficiencies through deceptive practices enforcement, especially where so many of these online safety laws that we talked about earlier are getting caught up in litigation and becoming unenforceable. So a couple of trends across these AG arguments. I'm not going to go through every individual suit here, but it's linked in the slides, so you guys can click through that when you're taking a look. But first is just omitting that companies were omitting known facts about the risks of harm to children, with the attorney generals commonly alleging that companies are in possession of unique and detailed internal information about the risks of harm posed by their services, but they aren't disclosing that necessary risk information to the public, and that's a deceptive trade practice. Some data practices tie-ins to some of these lawsuits, where multiple lawsuits are saying that the data practices played into certain safety defects and put minors at risk. There's misrepresentation claims where attorney generals are alleging that companies misrepresented platform or product safety to the public by claiming their service was safe for children and teens, including on press releases or in public statements by senior officials, despite knowing that there were still risks of harm and a lack of adequate safeguards. This is just what they're alleging, to be clear. And then, interestingly, there's also calls for age verification that, with attorney generals alleging that knowing these risks should have compelled companies to implement age verification, but they failed to do so, which would have been a key safeguard in being able to identify who's a minor and start to implement more specific protections, knowing that there is this risk of harm.
So as you
So
can tell, there is a lot, and I know we're over time. But do you want to go ahead and tie us up, Daniel? There's so much, including the cases going back there.
yeah,
Practically, it isn't going away.
yeah. So I think that some takeaways from these state level actions and the conversations that we've been having over the course of this webinar include, well, first of all, you know, yeah, this isn't going away. Monitor the state and federal legislative activity to determine coverage under emerging legal obligations. Make sure you're reviewing your data flows to ensure compliance with the new privacy requirements concerning kids and teens' data flows. And definitely prioritizing transparency and compliance documentation, especially with so many new approaches to these requirements or new frameworks that are going into effect, especially if regulators come around to inquire about things, being able to demonstrate how you're attempting and addressing compliance here is going to be critical.
With that, Ben, it's all yours. Thank you all, especially those who have stayed over time. We appreciate it.
No, thank you, Amelia, and thank you, Daniel. What an incredible presentation. Yes, so much good information on everything going on with children's privacy right now, which is clearly a lot. And yeah, we will have the deck for you and this recording after the webinar so that you have that information with you because I know it's a lot to have there. And yeah, I'll just give a quick plug for Privado AI. So we help companies monitor privacy compliance across their systems, websites, mobile apps, any internally developed software. We can scan that software in real time to make sure that consent is being honored, that if there's any age gates need to be checked, that your websites or mobile apps, your products are privacy compliant across all these regulations. So please reach out if you want to learn more about that. And also, if you're coming to IPP GPS next week, we will be there. Please stop by our booth to learn more about anything that we do, and we'd love to meet you. Otherwise, thanks again to our speakers today, and we'll see you next time. Thanks again.